This subject matter of copyright is nothing but it is a thing protected called the work. So he has the right to record the sound or to sell it or offer or hire any copy of that particular film. Under section 14 of the Act, it says the copyright for the purpose of Act. What is a copyright? It is a purpose. For the purpose of the Act, he has the exclusive right in order to reproduce the work in any material form. Hi and welcome to you all dear students. Hi, George Olime, Commerce Faculty, Department of Commerce, Vidhyaashram, First Grade College, the Temple of Excellence, MYSURU. Dear students, today I am going to take up session 1 of Unit 4, that is regarding Intellectual Property Act. Intellectual Property Act. So students, in the last class we finished about the contingent contracts, that is Unit 3. In Unit 4, we are going to take up related to Intellectual Property Act. Now let us understand the meaning and the definition of this Intellectual Property Act. What is an Intellectual Property Act and what are the various other topics which will be covered under this? Okay, so Intellectual Property Act, we say in short form is IP, is a creation of human intellect, is a formation or it is a creation of human intellect. It means it is the ideas, knowledge, invention, innovation, creativity, research, etc. All these are related to the human intellect. Human intellect or intelligence we say. So this intellect property or intellect property refers to the ideas, knowledge, invention, innovation, creativity, research work, all these things, and being the product of that human mind, and it is similar to any property. So it is similar to any property, whether it is movable or immovable. So this act is related to any of the property which is movable or immovable, and where it says the proprietor or the owner of that particular the product may be exclusively use his property at his own will and has every right to prevent the others from using it, right, and without his permission. So here under this Intellectual Property Act, it says it is the idea, it may be the knowledge, invention, innovation, research work, creativity, right, all this being the product of that particular human being or the human mind, and which is similar to the property of any human being, and which is movable. That property is movable or immovable, and wherein we call the proprietor, the owner of that particular property, he has every right to use it, and it prevents that particular property of his to be used by others. That is, only with his permission the others can use this particular property. Now the rights relating to intellectual property are known as intellectual property rights. So what are the rights are there which has been related to this intellectual property? They are called as intellectual property rights. So now coming to the copyrights. First we have copyrights. So we are discussing three importance here, that is related to the intellectual IP, intellectual property. One is of copyrights, then second is we have patents, right, and third is we have copyrights, patent rights, and the third one I'll cover you in the next class. So it says first we'll take up the copyright. So next we'll see the other two important aspects. Okay. So under Copyrights of India is the first Copyright Act which was passed in the year 1914. So in the year 1914, this copyrights was established, or the act was passed in the year, that is 1914 in India. Now at present this Copyright Act, that is 1957, because it has been amended every now and then. So it has been amended in the year 1957. Thereafter it was called as an act. So this copyright was first, it was passed in the year 1914, and at present we have this Copyright Act of 1957, right, and this will govern the copyright law in India. So this particular Copyright Act of 1957, it will govern all the copyrights related to the copyrights which has been related to that particular law, copyrights law, which is in India or which is prevailing in India. The original Act 1957, this one, the original Copyright Act of 1957, it has been amended again in the year 1983, then in the next year 84, then 1992, 94 and recently in the year 1999. So like this, the Copyright Act has been amended in the legislation, and now we have recently the 1999 Act, that is the Copyrights Act. Okay. Now coming to the trademarks. So I was telling you here, first one is the copyright, second is the patent one, and third is the trademarks. So these are the three important aspects here we are going to discuss in this particular unit. So as we are taking this particular copyright, let us understand this little bit in depth. So likewise, we have the trademarks also. A copyright is an intangible property. So like the trademarks, this copyright is also an intangible property where you cannot feel it or you can touch it. So this subject matter of copyright is nothing but it is a thing protected called the work. So what is the subject matter here in this copyright? The subject matter is nothing but it is the work of that particular person or the one who has taken that. That is, the copyright means it is given for the publishers or the authors who write books or they publish the books. So copyright subsists throughout in India. So first it says originally literary, then dramatic for musical and artistic works. So for all these 3 or 4 important works, this copyright is given. Then cinematography, film, then also sound recording. Now here the terms, students, which is defined in the Act is, it says apart from this works, apart from this particular works in copyrights, no other work is entitled to get the copyright under this particular Act. So only this original literary, then dramatic, musical and artistic work will be taken into consideration, right, according to this particular work, and it is considered as that work. And only no other work other than this is entitled to come under the copyright. Under section 14 of the Act, it says a copyright for the purpose of Act. What is a copyright? It is a purpose. For the purpose of the Act, this copyright is there. Now the copyright means the exclusive right. It is the right exclusively only given to that particular persons, that is to do or authorize the doing of acts. That means they are being given the permission to do it as well as for doing that particular act, that is the works, in respect of the work or any substantial part of that. Now let us see which are these 4 acts. We have 4 acts. First one will say literary, dramatic or musical work. Now here under this particular act, it says the owner has exclusive right. So the owner of this particular property, he has an exclusive right in order to reproduce the work in any material form. So he has a permission. Permission is given or the right is given to this particular the proprietor or the owner, where he can reproduce. Again he can, for example, he is printing a book. Again he can publish. Again he can reprint it in the coming years. So that permission is given to reproduce the work in any material form, including what? The storing of it also in any medium by electronic means. Not only the publishing it, but also he can store it in the form of electronic means also. He can keep it or store it, whatever the books he has published, right, in the form of authors. Then it means to issue the copies to the public. So he has a permission to issue that copies which he has published, which has published out. So that can be given to the public also, and perform or communicate the work to the public. So he can perform as well as he can communicate whatever the work he has done to the people or to the public, and make cinematography or sound recording in respect of the work, that is which is related to that particular work, or to translate any other adoption of the work, or to translate that particular work, right, into any other form. Secondly, we have computer programs. This is also one of the acts. So it says in addition to the above rights which is given, the owner has also the exclusive right to sell or give. So here not only to reproduce that particular what are the work he has done, the acts, and not only that, he has been communicating, he can reprint it or he can store it, and or also he can distribute it. Apart from that, the owner has the exclusive right to sell or give on hire. So that particular right also is where he can sell it or he can hire that particular rights which is given to him, or offer for sale or hire any copy of the program. So he can sell or he can hire that particular program which he is having, that copy which he is having. So the Copyright Amendment Act 1999 has added one more right along with all other rights, such as to sell or to give on commercial rent or offer for sale for any commercial rental or any copy of the program. So any of the program can be given as on rent, or it can be sold out also, or it can be sold, or that is on commercial rental or offer is being given for selling that particular commercial rental copy of that particular program. The third one is cinematograph film. Cinematograph film. It means the producer of this particular film, he has a right to make the copy of that particular film. So he has every right to make a copy of that particular film which he has produced, right, including the photograph of any image. He can also, that is including, he has a right to make a copy that is related to any of the image which is forming part of that particular film, and also he can sell or give that photo or the film on hire, right, or offer for sale. He can sell it also. Then he can hire any copy of the film. So he can give it on hire any copy of the film that is he has produced in order to communicate the film to the public, so that it can be communicated or it can be given to the public, so that the public also will be aware of his particular film. The fourth one is sound recording. What is sound recording? It says this is a composer. So here the composer will come into picture. So the composer is having exclusive right in order to make any other sound recording embodied to it. So he has a right to record the sound or to sell it or offer or hire any copy of that particular film to communicate that film to the public. So in the same way, the rights conferred by section 14 upon the author, that is one who is publishing the books, right, are the economic rights, because exploitation of the work by himself or by licensing it for royalty may bring economic benefit to the author. So here this particular rights confirmed by section 14, it says upon any author are economic rights. Economic rights is given because of exploitation of the work by himself, by the author itself, he can exploit that particular work, that is by licensing it or by by selling it for or giving the license for as a royalty, and he may get the economic benefit from out of it. So the object of copyright law is to encourage the authors, composers as well as artists to create original works. So what is the main importance or the objective of this particular copyright? It says the main objective of the copyright law is to encourage the authors, that is one who is publishing the books, then the composers, one who is composing the music or the whatever the films or the images, pictures, the artist, one who is doing the work, creative work, that is to create them in original work and thereby giving them exclusively. So they have been given the rights for limited period. So it is not that for whole year, it is for limited period, and to reproduce the work for the benefit. Again, they are given the right to reproduce that same particular work or the act which has been done of the public. So it is a negative right to prevent others from copying their work. So this particular right confirms that no other person other than the person who has given the right only can use it. They can reproduce it, sell it or offer it, or they can give it on rental or hire basis, but no other person is entitled to take this copy. That is why we can see copyrights ensured. So only author is prevented. When you take out some websites for the notes also, there you cannot copy that. You cannot copy it to your system or whatever the pages, right? So here it says that it has been restricted. Now coming to the term of copyright, it says copyright is not a perpetual right. It is not a perpetual right, but it exists for a specific term. So perpetual right means it is not for longer period of time. That is, there is no continued existence of it, but it is only for a specific time period. So after the expiry of that particular term or a period, the work will fall in the public domain. So once that particular term is finished, then that particular work will come to the public domain, and where it is being open to public, so that to use without permission of the owner. So here under this case, the owner will not have any right after the term expires or that particular specific period expires. So that will come under the public domain, and anyone can use, any public can use it without the permission of the owner of that particular property. So for literary, dramatic, music and artistic works, the term is 60 years. So for all these four, literary, dramatic, musical and artistic works, they are given 60 years time period, right, from the death of the author. For cinema, that is photography, cinematography, film, sound recording, it is also 60 years from the beginning of the calendar year. So the beginning of the calendar means from January we say. Next following year in which it has been published or released. Now coming to the important stages, students, here it is very important on part of your examination point of view, the registration, the procedure for registration of copyrights or the registration for the patent rights or the registration for trademarks. Okay, so they can ask you for 5 marks or also for 10 marks also. So it is very important. So it is a weightage on part of examination. Okay, first we'll see what are the registration procedures for the copyright. First it says register of copyrights. Register. That means they shall be kept at the copyright office. A copyright office is there where a register is been kept and it is been presented form and it will be called as a register of copyright. And what is the necessity of this? Where you are going to enter the name or the titles of the work, right? And the names and addresses of the authors, then the publisher's name, owner's name and the copyrights, and such other particulars may be prescribed. So according to this particular register of copyrights, so this particular copyrights office will be there. There you can see a register which is meant for register of copyrights. It will be there. And what is the purpose of it? So there you will be entering the names or the titles of the work which you have done, or the names and the addresses of the authors, the publishers, right? Or it may be the owners of any copyrights or the property, and such other particulars may be there in this particular copyright. That is which has been prescribed, that will be mentioned in this register of copyrights. Secondly, the registration of copyright. Now under this it says registration of copyright is optional. It is left to the option of the proprietor or the owner of the property. The act does not deprive any author of the right confirmed by this act on account of non-registration. Even though if the proprietor, owner or the author, if he has not registered it or registered his copyright, even though, then he will not be even, he will be still safe under this particular right, where he will not be deprived of any kind of right which has been confirmed or which has been given by this particular act. So he will get all the rights, and he is, where the author or any other person is there having that particular they can take that right of a copyright as part of their work or the act. So the main benefit of the registration is what? That is the prima facie evidence. So why you want to register your copyright? Because it will act as an evidence, the proof, the prima facie evidence or the proof in favor of the person. Why? Because that is in favor of person means in favor of the person, that is who has done the work or the art. So it may be author, publishers, then film directors or producers, like this, claiming the copyrights. So one who is claiming the copyrights, this will give us, or this will be standing as a proof or evidence. So the copyrights may be registered with the Registrar of Copyrights by filling the form 4 in a prescribed format. So how we are going to register it? That is, you need to register your copyright with the Registrar of Copyright by filling the form number 4. So, and whatever the prescribed things are there, that has to be completed, the work. Second thing is entries in the Register of Copyrights. After once it is been entered, registered, and filling the form of number 4, comes to the, what are the other entries which has to be entered in this Register of Copyrights. The author or the publisher or the owner of any other person who is interested in the copyrights, who wants a copyright in any other work or any other application is prescribed form, can be accompanied by the prescribed fee to the Registrar of Copyrights for entering the particulars of the work in the Register of Copyrights. So simply you cannot go and just enter your name or this one in the Register of Copyrights. For that there is a prescribed fee. That prescribed fee has to be paid on part of that particular person, one who wants that particular copyrights, and then only his details, all the details related to that particular work or the act of copyrights will be entered in the Register of Copyrights. Then secondly it says on receipt of the application, once they receive the application that is related to any of the work under subsection 1, the Registrar of Copyrights, what he does, after holding such enquiry, first you will have an enquiry as such, whether it is deemed to fit. So whether this particular copyright, whether is that particular copyright which is been has to be registered, whether it is fit to get the copyright or not. So you will do an enquiry, then enter that particulars, all the details of that particular work in the Register of Copyrights. Third is form and inspection of register. So third important procedure in registration, it says the form and inspection. So here they will undergo or they will scrutinize the form which has been which has been applied or which has been given by the author or publisher or any other person on behalf of that particular work, right? And also they will inspect the register. So the register of copyrights and the indexes thereof kept under this act shall be at all reasonable times open to the inspection. So whatever the register you have kept there in the Register of Copyrights Act, so that will be kept open. So there is a transparency, right, for inspection, and any person shall be entitled to take the copies. So if I am willing, if I want, I can also take the copy or make an extract from that. That is, take a duplicate copy of whatever it has been entered. That is in such kind of registers which is there on payment of such fees. So you need to pay the fees if you want a copy of what is there in the register where that is your copyright, or that is the work which is been registered or it has been entered to the conditions as may be prescribed. Fourth one is Register of Copyrights. Under this, the prima facie evidence of particulars entered therein. So here, what are the important evidence? All that particulars details will be entered in this Register of Copies, and the Register of Copies shall be the prima facie evidence, as I told you, and where the particulars have been entered in that particular register therein, and the documents purporting the copies of any entries are there. So related to that particular details, whatever the documents has been submitted, even that also will be entered in this particular, seeing that particular documents or supporting that particular copyright, so or the work, that also will be there in this particular Register of Copies. The next one is correction of entries in the Register of Copyrights. So if there is any correction to be made in the Register of Copyrights, that also can be done. The Register of Copyrights may, in the prescribed cases, not every time, only in some cases, prescribed cases, and it is subject to prescribed conditions, only to some conditions, amend or alter the register. So he has that power authority to amend it or to alter in case if there is any corrections to be made in the Register of Copyrights. And first one is correcting any error in the name. So he cannot just correct whatever he wants. He has to do the correction or alter there in the Register of Copyrights. That is first and foremost correction if any error, any mistake is there in the name of the author or the address of the author or the particulars which is given by the author or publishers or any other person of the act. Then second one is correcting any other error, any other mistake which may have arisen thereafter by incidental slip or omission. Sometimes due to carelessness also, sometimes it may be to oversight. So you might have left out something or you might have written wrongly something. So even in that case you can alter it. So the Registrar of Copyrights, he will undertake all these activities. Next is Rectification of Register by Copyright Board. So here the Copyright Board, on application of the Register of Copyright or any other person aggrieved, shall order the rectification of the Register of Copyrights by, first one, the making of any entry wrongly omitted to the register. So here the rectification of Register by Copyright Board. So the Copyright Board, they have that authority to rectify or amend on the saying of the Register of Copyrights or any other person related to that particular authority. So here they are going to make rectification, that is making of any entry wrongly omitted. So if you have any entry it is been made and if it has been wrongly, it has been omitted, means left out in the register, then they can make rectification in the Register of Companies. Second one is the expunging of any entry wrongly made in, if your entry has been a wrong entry, wrongly you have made that particular entry, or remaining on the registrar, which has been already there in the registrar, and the correction of any error or defect in the registrar. So to correct it or any other defect is there, so to correct that in the registrar, the rectification of Register by Copyright Board will be taking place. Next is entries in the Register of Copyrights to be published. So under this case, it says every entry made in the Register of Copyrights, what are the entries, the particulars that is been made or it is been entered in this particular copyrights of any work are entered under the section 45, where the correction of every entry, right, made in such register section 49, and also they say that every rectification order which is been done in order to see that everything is correctly fitted in shall be published by the Register of Copyrights in the official gazette or any other manner as it deemed fit. So here the main thing is they will see, go through all the register of copyrights, and they will see that each and everything aspect is been correct. Only then they are going to publish it to the public. So meaning and definition of intellectual property, that is, it is a creation, intellectual property or IP is a creation of human intellect, that is ideas, knowledge, or it may be creativity, innovation, research work, etc. Right, all of human being or human mind, that and it is related to, similar to any property of a human being which is movable and unmovable. Then the copyrights in India was first passed in the year 1914, and presently we have the Copyright Act of 1957, and it was amended as per the year 1983, 84, then in 1992, 94, and now it is 1999. Like same like trademarks, the other copyright is also an intangible property where you cannot feel it or touch it, right? But the subject matter of copyright is very, very important, and that is being protected. That particular theme or the subject matter is called as the work, and the copyright subsists throughout India in the form of original literary, dramatic, music, as well as artistic works. Then cinematograph, film, as well as sound recording. So I explained to you all these things, the acts, literary, then computer programs, cinematography, films, then sound recording, then registration part I told you. So registration of a copyright, how the registration takes place, procedure. First is the register of copyrights. Secondly, registration of copyright. Third is entry in the register of copyrights. Form and inspection of registers, a register of copyrights. Then correction and entries in the register of copyrights. Rectification or register by copyright board. Then entries in the register of copyright, as well as which has to be published. So students, I hope that you understood this particular topic which I explained to you in this particular session. So see you in the next session. Until then, take care. Have a nice day. Thank you, students.